Ladies and gentlemen, welcome to our program, the 2024 Joseph Story Distinguished Lecture, Why Originalist Courts Need Originalist Classrooms. Please welcome John Malcolm, Vice President of the Institute for Constitutional Government at the Heritage Foundation.
Thank you. Well, good afternoon. I'd like to welcome you all to the Heritage Foundation, to the Joseph Story Distinguished Lecture. My name is John Malcolm. I'm the Vice President of the Institute for Constitutional Government. This lecture has been named in honor of one of our country's most eminent judicial and legal scholars, a man who in fact distinguished himself in many different ways. Joseph Story was involved in politics and civic activities in his native state of Massachusetts. After several years in private practice, he served in the Massachusetts State Legislature for a brief period of time as its Speaker of the House, and then in the United States Congress. Pretty remarkable when you consider that he did all of that before being confirmed as an Associate Justice on the Supreme Court at the age of 32, the youngest justice in our nation's history. In addition to serving with distinction on the High Court for 33 years, Story was instrumental in establishing the Harvard Law School and served as its Dane Professor of Law. Story was also an accomplished writer whose articles and books were praised on both sides of the Atlantic. Of course, his most famous work was his Commentaries on the Constitution, which demonstrated his commitment to faithfully interpreting the Constitution as it was understood by those who wrote and ratified it. The influence of Story's commentaries continues to be felt among the judiciary and constitutional scholars to this day. We are fortunate tonight to have Judge Amul Thapar as this year's Story lecturer. His talk will be on how originalist courts need originalist classrooms. Judge Thapar sits on the U.S. Court of Appeals for the Sixth Circuit, having been confirmed to that court in January of 2017. He began his judicial career, however, in 2007, when he was confirmed as a federal district court judge in the Eastern District of Kentucky, making him the first South Asian Article III judge in American history. Before joining the bench, Judge Thapar was a United States attorney for the Eastern District of Kentucky. He also served as an assistant United States attorney in both the Southern District of Ohio and the District of Columbia. And he was in private practice at Williams & Connolly here in D.C. and at Squire, Sanders & Dempsey in Cincinnati, Ohio. He began his legal career as a law clerk to Judge Arthur Spiegel of the U.S. District Court for the Southern District of Ohio and Sixth Circuit Judge Nathaniel Jones. In addition to his judicial duties, Judge Thapar has taught at several law schools, including Notre Dame, the University of Virginia, and Vanderbilt Law School. He has written many scholarly articles, and he recently wrote a book entitled The People's Justice, Clarence Thomas, and the Constitutional Stories That Define Him. And based on previous conversations, I can also tell you that Judge Thapar knows a thing or two about bourbon. Please join me in welcoming Judge Amul Thapar.
That was the best line of all. I do like bourbon. Well, thank you for having me, John, and the Heritage Foundation. It's a real honor and privilege to be here. I love to come to the Heritage Foundation. I was just here talking about my book not too long ago, so it's great to come back and be in the same room. And I am always happy to talk about one of my favorite subjects, originalism. As you all know, originalism is the idea that the Constitution has a fixed meaning, and that judges should follow that fixed meaning rather than their personal policy preferences. That should not be controversial. Indeed, it seems to be the point of having a written Constitution. As Joseph Story put it, the Constitution is the will, the deliberate will of the people. They have declared under what circumstances and in what manner it shall be amended and altered. And until a change is effected in the manner prescribed, it is declared that it shall be the supreme law of the land to which all persons, rulers, as well as citizens, must bow in obedience. When it is constitutionally altered, then, and not until then, are the judges at liberty to disregard its original injunctions. In other words, now I'm back talking by myself without the aid of Justice Story. In other words, the people set out the Constitution's original meaning, and judges must honor that meaning when interpreting the Constitution. But in our culture, where too many are willing to bend their views of the law to the politics of the moment, originalism needs defending. It probably always will. Today, originalism faces challenges on three fronts: in the federal judiciary, in academia, and in legal practice. Against all odds, originalism has begun, slowly but surely, to carry the day in the federal judiciary. As you all well know, originalism has become the ascendant method of constitutional interpretation during the past decade, and rightly so. Anytime a case involving constitutional interpretation arrives at the Supreme Court, each justice engages with originalist evidence. Majorities and dissents will disagree on questions of constitutional interpretation, but all justices would probably agree that evidence of the Constitution's original meaning plays an important role. That is not to say the work is done. Our nation's history shows that judges have time and time again been tempted to stray from the Constitution's meaning towards their personal preferences. But the progress we have made since the heydays of Attorney General Edwin Meese and the late, great Justice Antonin Scalia cannot be ignored. But for originalism to really work, we must make headway on the other two fronts, academia and the legal practice. Start with our nation's law schools, where much is amiss. We do not have time to catalog all the ills of the legal academy, but suffice it to say that today's professors are overwhelmingly anti-originalist. And even setting personal views aside, too many of these professors teach widely accepted originalist methods through a distorted, uncharitable, and often inaccurate lens. This means that most students never engage with originalism in a serious way during their law school careers, much less learn how to do originalism in practice. For originalism to get a fair shake and gain adherence in law schools, there must be an environment of free inquiry and debate. As Thomas Jefferson once said, "Truth is great and will prevail if left to herself. She is the proper and sufficient antagonist to error and has nothing to fear from the conflict, unless by human interposition, disarmed of her natural weapons, free argument and debate." More on this later. The third front of this fight is in the American bar itself. When we think of constitutional interpretation, we often jump to the Supreme Court or the Court of Appeals, and for understandable reasons. But the main victim of the Academy's failure to teach originalism are the trial courts in both our state and federal judicial systems, and the parties whose cases they adjudicate. It is those courts where judges and lawyers are the most overworked and where the Academy's failure to teach originalism is the most conspicuous. Imagine how many cases would have turned out differently if lawyers had been taught in law school how to make originalist arguments in their client's favor. In our system of adjudication, which depends on principles of party presentation, this deficit will persist unless and until law schools equip future lawyers and future clerks with the necessary facility in originalism. It's amazing how many times my colleagues and I say, if they only would have made argument X, their client might have had a chance. But far too many lawyers do not recognize the originalist's arguments. That is, arguments about the Constitution's original meaning that are available to their client. This is a disservice to the American public, and it can be traced back to the training that too many lawyers receive. To be sure, there are some within and without our ranks who believe that originalists can never prevail in academia or legal practice. Originalism will never work, these skeptics say, because originalism is too difficult. To some extent, they are right. Originalism is hard. Making it up would be easy. I've lost a lot of sleep and a lot of hair trying to do my job correctly. To critics who say originalism is hard, we should ask, compared to what? As Justice Scalia often did. Compared to making it up? Sure. But law is not supposed to be easy. It's supposed to get things right. And when we are interpreting our Constitution, the cornerstone of our nation, getting it right for our clients and our countrymen should be the priority. In my speech today, I will outline how we can turn the anti-originalist tide in America's law schools and eventually in the American bar. First, I'm going to lay out the current failings in the academy that hinder sound constitutional interpretation. I'll focus on how law schools should change their teaching methodology and scholarship to better equip lawyers to do real originalist law, not the purposivist and or ideological mush that law professors often push on their students. Second, I'll discuss the effects of Academy's failures in the trial courts, which I witnessed firsthand as a district judge. And third, I'll discuss the role of appellate courts in helping make originalism work in the trial courts. But it bears emphasis that while judges can make a difference, making originalism work in the courtroom can be achieved only through fundamental changes in the classroom. I start where every lawyer's career begins, the academy. Although most academics will not admit this, law school is in many ways a trade school. The point of law school is to train lawyers how to practice law. But rather than teaching students how to actually practice law as lawyers in a constitutional republic, law schools and their professors have focused on teaching students how to create law. They don't try to teach interpretation. Instead, they teach legal creativity. For example, they ask how students can minimize certain enumerated rights while effectively creating new ones that aren't even in the Constitution. But legislatures are the ones who make law. Lawyers and judges just interpret the law. By taking the approach they do, law schools are failing to teach the prevailing method of constitutional interpretation. Such neglect raises a question. What is the goal of law school? Is it to train future lawyers, or is it to train politicians? To ask the question is to answer it. But rather than teaching law students how to be lawyers, too many law schools are teaching their students postmodern philosophy, critical theory, and the need to abolish the carceral state. Professors focus too little on understanding cases on their own terms and too much on what political considerations are supposedly motivating a court's opinion. So when a court employs originalism, the professors instinctively misconstrue it. Surely, they tell their students, the court's originalist analysis is just a smokescreen for some nefarious political goal. They can't fathom that originalist interpretation is an attempt to get legal interpretation right. They claim it must be a means to achieve bad policy ends. In doing that, professors misrepresent originalism, which creates serious problems with profound consequences for our profession and country. After all, lawyers cannot best represent their clients when the law schools they attended never supplied them with the tools necessary to succeed in today's courts. Yet that's the sad state of our profession. Many have read Charles Beard's economic interpretation of the Constitution and postmodern critiques of our law, but few have read Joseph Story's commentaries on the Constitution, or for that matter, the Constitution itself. The failure of law schools is undoubtedly creating problems for district courts and litigants across the United States. Indeed, lawyers often fail to make the best arguments on behalf of their clients. This is not because of personal incompetence. It is because of poor training by our nation's law schools. That said, I believe that we can and must change the misdirected culture of legal academia for the sake of our country and for the sake of their clients who deserve sound representation. I'm an optimist. For originalism to work in our legal system, the academy must step up in two ways. First, in the skills that law schools impart to their students, and second, in the research professors conduct. Step one, law schools must teach originalism to their students. I'm fortunate to have clerks that come from law schools with renowned faculty. But my clerks tell me that they had the opportunity to take one, maybe two classes that seriously engaged with originalism. More classes ridicule and straw man originalism than grapple with or teach it. For example, many 1L constitutional law professors devote a class or two to studying constitutional methodologies, including originalism. And how do they study it? My clerks tell me that the case that's most often presented as an example of originalism in action is Dred Scott. Yes, you heard that correctly, but of course that case shows the opposite, the danger of purposivism and making it up. In Dred Scott, the Supreme Court deviated sharply from the original meaning of the Constitution to hold that Black Americans could never be citizens. The ruling stained our republic. Indeed, as several originalist scholars point out, Dred Scott is where substantive due process came from, not exactly an originalist concept. Perhaps professors could instead use a case reflecting the work of today's originalists, one by the late, great Justice Scalia or Justice Thomas would do. At the very least, law schools must start teaching originalist methodology. In particular, original public meaning originalism. After all, that's the predominant originalist philosophy in the courts today. It is malpractice for law schools to send their students out into the world without teaching them the prevailing methodology in the federal courts. And indeed, the principal method of constitutional interpretation for most of our nation's history. But theory alone is not enough. Schools must show their students how originalism is done. At a minimum, law students should learn about founding era sources and which of these sources are most helpful when trying to understand the Constitution's original meaning. Indeed, there are many law students, including some of my own law clerks, who have never read the Anti-Federalists. A good example is a new course taught at Notre Dame Law School called History and Language in Practice. This course introduces students to sources and methodologies of two areas which have become particularly important with the increased influence of originalism, history and language. The course's goal is to teach students how to research and then use originalist sources in practice. Contrast that with courses that teach students to use legal interpretation as a tool of resistance, or examine the lessons Bonobo's sisterhood supposedly has for structuring human society. Yes, those are real courses. At schools like Yale and Harvard, no less. Who do they benefit? Not your future clients. Without originalist instruction, young lawyers will lack the toolkit that will enable them to best represent their clients. Before I go further, I want to be clear about one thing. I'm not saying lawyers should only make originalist arguments. They should make all the arguments that benefit their clients. But in today's legal world, the problem is that they are not equipped by law school to do so. To be sure, many scholars are trying to make up for their institution's deficiencies. Some of these scholars think originalism is the correct approach to interpreting the Constitution. Some do not. But all these scholars, no matter their priors, are doing important work. No matter how good these professors are, though, they can't make up for an institution's deficiencies on their own. In addition, at some law schools, law students are taking their education in their own hands and trying to make up for the deficiencies. Some form reading groups. These reading groups focus on subjects like originalist theory, the Federalist, Anti-Federalist debates, and the Bill of Rights. Others debate originalist theory in the halls or at lunch talks, but this, like many other things, is merely a Band-Aid on the school's deficiencies. And other things students are doing is pushing their schools to form law school clinics that engage more seriously with the original meaning of the Constitution. Indeed, several schools have formed religious liberty clinics. BYU has a corpus linguistics clinic. At least these clinics give students an opportunity to study originalist arguments. Finally, there are a few law schools that are also striving to be intellectually diverse. Notre Dame and Scalia Law come immediately to mind. These schools not only prepare their students to zealously represent their clients, but they also teach students how to work together, no matter one's views. You don't hear about students shouting at judges or professors at these institutions. And students, left, right, and in between, enjoy these law schools and learn in a robust and respectful environment. It isn't a coincidence that the students who appear most happy are also the ones attending law schools that foster open debate and discussion. Other law schools should take note. As Notre Dame's Dean Marcus Cole recently commented, half the American people could be characterized as conservative. Half the legal profession can be characterized as conservative. In fact, there's nothing wrong with being conservative. It's normal. It's normal everywhere except for in the legal academy. But while other schools see it as a badge of dishonor to have any conservatives on the faculty, Dean Cole knows that such one-sidedness does not serve students well. Thus, Notre Dame Law School strives to hire an intellectually diverse faculty, and judges, among others, are noticing. Their clerkship numbers are swelling. But these lone scholars and institutions are fighting uphill, and they can't prevail alone. Donors to law schools should reconsider their support unless institutions show genuine commitment to intellectual diversity, including by hiring more originalist scholars and allowing students to learn about the Constitution's original meaning in their curricula. Donors should consider endowing chairs if, but only if, they trust the individuals who will be picking the professors. In addition, many law school faculties are funded by taxpayer dollars, whether directly or indirectly. As a result, law professors are public servants who should be serving the common good rather than pursuing their own political agendas. Producing something of practical value, namely excellent lawyers, is in their interest if they want taxpayers to continue footing the bill. And if that is not their priority, then taxpayers should take note and demand change. Of course, until law schools come around, civic institutions, judges, and lawyers in private practice must pick up the slack. The Heritage Clerkship Academy, for example, comes to mind as a place where students can go to sharpen or hone their understanding of the Constitution's original meaning. Seminars like the one Randy Barnett operates help too, as do the Federalist Society's debates and events, which take originalist arguments about the Constitution seriously. The second change academia must embrace to make originalism work is for scholars to devote time and resources to refining the original meaning of constitutional provisions. I don't know many judges that wouldn't welcome a comprehensive historical account of each provision of the Constitution. Scholars are best equipped to produce this account, but no single scholar can do this on his own. Even Joseph Story had his limits. He didn't get to the 11th and 12th Amendments in his great commentaries on the Constitution. Instead, like any intellectual enterprise, originalism only develops and reaches the truth through the exchange of ideas. This body of work requires collaboration and synthesis of professors, judges, and the bar. Indeed, if this were to happen, the Heritage Guide to the Constitution would have to be a multi-volume set. I've encouraged that the next version be so. As courts have started to take the original meaning of the Constitution seriously once again, people are realizing that many provisions have not been definitively interpreted. This provides scholars and lawyers alike a unique opportunity. The best scholars will point us to the primary sources and legal principles that we can use to understand these provisions. Such principles and precepts will help us determine the meaning of often difficult to understand provisions. The same is true of originalist resources that allow legal professionals to access founding era sources. As I mentioned, BYU has the world's leading corpus linguistics database, which digitized and made text searchable thousands and thousands of hard-to-read originalist sources. Scholars should have a strong incentive to do originalist work. It is relevant. At a time when the academy is navel-gazing and disconnected from the practice of law, originalism is where a scholar can generate a real, meaningful impact. Look at how the brightest scholars being cited by the court today are almost all originalists, or at least take the original meaning of the Constitution seriously. Indeed, even before Justices Gorsuch, Kavanaugh, and Barrett were appointed to the Supreme Court, nearly all the most frequently cited scholars conducted originalist research, and that certainly has not changed. By the same token, the purposivism of the American Legal Academy is becoming increasingly irrelevant in today's judging. In 2011, Chief Justice Roberts poked fun at academic work, describing its attention to obscure topics like the influence of Immanuel Kant on evidentiary approaches in the 18th century Bulgaria or something. Things have not improved much since then. In fact, one study found that 82% of law review articles had 0 citations within their first 5 years after publication. And another study found that 43% of law review articles are not even cited, not once. With such favorable pressures, I believe the conditions are ideal to create change in the legal academy. We've established that the academy is failing in the skills it teaches and the scholarship it produces. Now, how does this affect the district courts? Everyone here knows doing originalism is no easy task, and leaving district judges to do it alone would be impossible. It isn't as simple as picking the best policy or outcome. Rather, as we discussed, to be originalist judges, you must probe the meaning of a provision of the Constitution at the time of the founding. This raises a host of questions. Where to start researching? What sources are most probative? What years are most relevant? What happens when historical sources have divergent meanings? When can we be confident that we have approximated the original meaning? Scholars devote years writing books and law review articles to answer these questions in the context of specific constitutional provisions. And the Supreme Court has the benefit of dozens of amicus briefs when the historical meaning of a constitutional provision is at issue. For example, in Bruin, the court had the benefit of 84 amici, and the Rahimi court had 60. But district judges have neither the luxury of time nor the volume of research to conduct that analysis in the first instance. I know this from firsthand experience. I served as a judge on the Eastern District of Kentucky for 10 years. Driving from my duty station in Covington, Kentucky to try cases in Pikeville and London, Kentucky, left me precious little time for founding era research. One lead I'm glad we pursued arose in a case called Sargent v. McKinstry. The plaintiff in that case was seeking to withdraw the case from bankruptcy court to federal district court. Yes, it was scintillating. The crux of the issue was whether the plaintiff had a right to a jury trial on her breach of fiduciary duty and gross negligence claims in federal court. Figuring out whether these claims were legal, entitling her to a jury trial, or equitable, which meant no jury trial, required comparing the nature of plaintiff's claims to 18th century actions in English courts before the merger of law and equity. It also required reading sources ranging from a 1742 opinion in the English Courts of Equity to an 1830 Justice Story opinion to a multitude of treatises and law journal articles. This was not easy, especially with trials and sentencings going on. But I had two advantages most district judges don't have. I had clerks well-versed in originalism who were committed to working day and night to figuring it out, and I had excellent lawyers who were willing to chip in and do the necessary research. And yes, for those of you that are interested, we ultimately concluded the plaintiff was entitled to a jury trial. From my current position on the Sixth Circuit, I can say with certainty that being a district judge is not easy. They have fewer clerks, less time, and not as much help from attorneys, most of whom are not trained in originalism and don't even know that certain arguments exist on behalf of their clients. This, along with a busy docket, means many arguments are never raised or even recognized. Originalism is now the predominant judicial philosophy for good reason. It is the best way to ensure that judges reach fair and equitable results for the litigants before them. But many arguments are still left unmade or undeveloped, and we can't expect busy district courts to do it alone. And it's hard to fault the district courts for this. There are, however, a few things judges should consider doing when the arguments are flagged, meaning raised, but not effectively briefed. They don't have to go it alone. In those cases, district courts should consider asking for supplemental briefing with specific questions, asking for amicus briefs, especially from the law school clinics that are getting stood up, or even issuing a general order encouraging amicus briefs from anyone interested. Until the broader legal profession catches up, appellate judges need to spend more time trying to make life easier for the district courts. How? By distilling doctrines and rules for district judges to follow within the constraints of Supreme Court precedent and the Constitution's original meaning. This approach holds true for both substantive law and for methodological questions like how to apply originalism in adjudicating cases. Here, the task of an appellate judge is to make the originalist inquiry clear and easily transportable into the context of everyday litigation. An area where we have already sought to do this is the Second Amendment. Since the Supreme Court's decision in Bruin, hundreds of criminal defendants have challenged their convictions for being a felon in possession under Section 922G1 as unconstitutional. These challenges have left district courts scrambling. They have wielded vastly different methodologies in evaluating the constitutionality of Section 922G1 and predictably disparate outcomes across the country. This past summer, one such case arrived on our docket, United States versus Eric Williams. It involved a defendant who argued that his indictment for being a felon in possession under 922G1 should be dismissed because the statute violated the Second Amendment. Our task was to determine whether 922G1 is consistent with our nation's history and tradition of firearm regulations as the Supreme Court's precedents in Bruin and Rahimi dictate. So we took a deep dive into the Anglo-American history of firearm regulation and so-called dangerous persons. And after diving into the founding era sources, the constitutionality of the felon in possession statute became clear. Anglo-American legislatures have long barred classes of people considered dangerous from possessing firearms. But how do we apply that general principle to offenders like Mr. Williams? To figure that out, we had to look at the way crimes were classified at the time of the founding and throughout American history. We found roughly three categories. First, crimes against the person, such as robbery, murder, and attempted murder. Convictions for such crimes were and are strong evidence a person is dangerous. The second category was crimes posing a significant threat of danger, such as drug trafficking. And third, crimes causing no physical harm to another person or the community. Such crimes may include mail fraud, forgery, or if you're living in New Jersey, pumping your own gas, or opening a bottle of ketchup in a grocery store. This last category of crimes could sometimes result in a finding that a person is not dangerous, even if they lack proper New Jersey etiquette. In creating these categories, our court was not setting out a categorical approach to determine whether a defendant was dangerous, but we were making the historically rooted, common sense point that certain categories of offenses will more strongly suggest an individual is dangerous. In this way, district courts can more easily adjudicate as-applied challenges to the felon in possession statute under Bruin's history and tradition framework. The idea was to produce an opinion that was faithful to the Constitution's original meaning and Supreme Court precedent, while also being straightforward for district courts to apply. In Williams, we then applied the framework ourselves and concluded that Mr. Williams could be banned from possessing a firearm since his violent past put him in Category 1. Zoning out, my hope is that this framework for analyzing post-Bruin challenges to the felon in possession statute will translate what history and tradition dictate into a feasible inquiry for district courts. District judges won't be tasked with figuring out whether James Madison contemplated disarming someone who was convicted of second-degree burglary. Instead, the district judge will already have the relevant analytical background to work from, that the Second Amendment allows legislatures to disarm dangerous persons, and certain crimes are indicators that someone is dangerous. Such fact-bound questions are ones that district judges are well-equipped to answer, especially when aided by other important doctrines like the party presentation principle that channel the exercise of judicial power. I have just described how appellate courts can synthesize history and precedent and make them more straightforward for district courts to apply. The process underscores a more fundamental point about the role of appellate judges in making originalism work. Appellate courts act as middlemen between the Supreme Court and district courts. They synthesize the precedent from above and distill it for the courts below. Originalist opinions are no different. Appellate judges must take the principles set forth in Supreme Court opinions and produce clear, historically accurate opinions so that lower courts may more easily apply those opinions to novel facts. Unlike the district courts, appellate courts have the time and resources to do this well, as long as they remain faithful to the Constitution's original public meaning. But even so, appellate judges need clerks and lawyers that are equipped to undertake this inquiry and understand it. That's where law schools come in once again. Before I wrap up, I want to thank the Heritage Foundation and other such groups and schools for teaching originalism, textualism, and the history of our great nation. Ultimately, this problem can only be solved by the law schools, but groups like Heritage are doing an admirable job of filling in the gap. Law schools would benefit from studying what they are doing to equip some of our nation's finest lawyers. And we all might want to think twice before sending money to law schools. Every one of us, including the taxpayers, should be demanding that law schools hire professors who are committed to educating people about what the Constitution means, not what the professors wish it meant. Taxpayers and their representatives should be revisiting the way faculty are hired and tenured. But getting taxpayers engaged is no small task. Today, the public greatly misunderstands what courts are doing. Most would rather vilify the courts than explain in good faith what they are actually doing. The task of clearing this up falls of those of us in this room and beyond. Justice Scalia made great strides in bringing the Constitution's original meaning back to the fore. Today, it is not novel to start with the text of the statute or the Constitution. Thank you, Justice Scalia. I think the public would be surprised to learn that this wasn't the standard practice in the courts when Justice Scalia came on the scene. But we need to take the next step and educate the public about originalism. My book, The People's Justice, was an attempt to do that. The reaction I received showed me that most members of the public agree that originalism is what the courts should be doing. We are a constitutional republic, And most Americans think we should follow the Constitution. We should not shy away from defending that principle. But one book or one speech will not do the task. It is the duty of each lawyer, judge, public servant, and citizen, everyone in this room, to do their part. Write, speak, educate. And make no mistake, money talks. Only when the taxpayers and donors alike demand it will law schools start to change. When law schools do change, the hefty price paid for a law degree might actually be worth it. Because lawyers will leave law school equipped to practice in today's courts. Thank you very much.
So in a few minutes, we'll open it up. I think we'll have time for a couple of audience questions. I would advise people, please identify yourself, no speeches, ask a question, and keep it short. So I have a couple of questions, though, to begin. So you mentioned a couple of courses that are being taught. You said the Bonobo Sisterhood at Harvard Law School, Decentralized Resistance, that's the Yale course. You also mentioned a few schools, Notre Dame, BYU, Scalia Law School, that are actually making efforts to teach future lawyers to, surprise, surprise, be good lawyers. But the problem is I actually think worse than you portrayed. So for instance, if you're a Stanford law student, you can take a class on violence, resistance, and the law. At Columbia Law School, you can teach breakthrough and abolition.
They actually practice that sometimes at Stanford.
So at Columbia, you can take breakthrough and abolition, that's of prisons, through transformative learning exchange. At University of Pennsylvania, they have a class, Race, Law, and Resistance, and another one on community lawyering to end mass incarceration. University of Virginia Law School, you can take Feminism and the Free Market, or Race, Class, and Democratic Legitimacy.
Where was that, Virginia?
The University of Virginia. If you want to learn more, by the way, my colleague Hans von Spakovsky and Christian Adams have a whole series in PJ Media. You can look these up. Believe me, I could go on, but I think you get the point. In short, liberal groupthink and cancel culture for conservative viewpoints are alive and well on today's campuses. Now, a couple of your judicial colleagues, most prominently Fifth Circuit Judge Jim Ho and 11th Circuit Judge Lisa Branch, have selected a few schools that they consider to be particularly egregious and have said that they're no longer going to hire law clerks out of those schools. I'm curious to get your reaction to that, and if you think that goes too far, what, if anything, do you think judges should do?
Well, I think I appreciate that that's the tact they've taken, and that every judge should choose what tact is best for them. I think for me, I think speaking out about it's important. Putting pressure through donors and taxpayers, as I mentioned, I think is critical. The reason is I don't think, as much as we may think, I don't think kids in the military that are going to law school right now are paying attention to what Amul Thapar is saying, or any of my colleagues. I think they have much bigger things to worry about. And I don't know that those students should be excluded. I worry that there's kids like myself, Jack Goldsmith talks about this, that went to law school. I didn't even know, what a clerkship was. I'm still the only person in my extended family that went to law school. I had no guidance, and I just showed up. I wasn't even a conservative then. I was a nothing, right? I was a normal college kid that enjoyed college, played sports, had fun, probably drank a little too much, and went to law school. And I got there and I saw I thought I was going to be interpreting text, interpreting law. That's just kind of logically, if you have no idea, you think that's what you're going to do. And then you get there and it's craziness. And a lot of those kids, I think, either quietly or vocally moved to the right. And during law school. And so I struggle with excluding a whole group of essentially students that believe in originalism or want to do originalism to punish their law school. Now, I'm not saying it might not be effective. I'm not saying that Jim and Lisa haven't made great strides. I'm saying it's just not the tact I and others have taken, because we want to encourage the schools to change. We're very vocal about it. At the same time, we don't want to punish the very students that believe in originalism as a result.
So you also suggested rather provocatively, you just said it here now, that taxpayers should stand up and take notice, and they should decide whether they should, this was your words, continue footing the bill by providing funds to law schools. Now, obviously, individuals can make whatever charitable donations they wish to make, but given the fact that the government can't pick and choose among viewpoints which schools are going to subsidize and not subsidize, what exactly do you have in mind when you talk about taxpayers fighting back?
Well, I'm kind of talking off the top of my head now, but things I think that would be relevant to taxpayers is how relevant is the work that they're paying for. And if you publicize those classes, if you start to talk about what lawyers do and how arguments are left on the table, and one metric to judge professors, whether hiring or tenuring, is how often are their articles cited in briefs and cases. And I'm not saying everyone has to be vetted by the Heritage Foundation. Of course, I would love that. But you look at someone you look at someone like Akil Omar, who, in the 2017 study I looked at, was one of the most cited scholars in America. Now, he himself, I think, says he's a Democrat. But at the same time, he does a lot of interesting originalist work that every judge is going to look at. And so, it's not that they're all going to be some of the, Sharif Girgis. They're going to be Akil Omars. There's going to be others like that. I'm not putting a political ideological test. I'm just saying their work has to be relevant. And if 82% of law reviews are completely irrelevant, then what are we doing? And why are taxpayers paying those professors' salaries if they're teaching Bonobo's Sisterhead and writing articles that are completely irrelevant?
All right, let's open it up for questions. Let's get down here for Devin. Wait for you to get a microphone again. Identify yourself.
Devin Watkins, Competitive Enterprise Institute. The problem, it seems for me, for the academics really is in the hiring process. A lot of times in the hiring process, it seems like these schools get a bunch of the existing law professors together and ask if there's like a consensus about a candidate. And this allows some of the law professors, especially those with more extreme views, to blackball, especially conservatives, in getting such positions. How should the hiring process be changed to allow more intellectual diversity?
Yeah, that's a great question. I think I'm sorry. I don't know enough about the hiring process other than I totally agree with what you said. The premise of your question is absolutely right. The one thing I mentioned that I could see is donors. You've seen this, Bill Ackman has had a tremendous impact by demanding that funds not be sent to certain schools that were exhibiting anti-Semitic tendencies and other things. The same can be done with donors. I got to imagine conservatives donate to these law schools. So organizations could make them aware. They could, instead of donating to the schools, endow chairs and have people they trust picking the professors. So that's one step in that direction. Another is what some governors are doing, where they're taking action, at least at state schools. There's no reason they can't change the process, put in deans that are open to hire, like Marcus Cole, that will hire intellectually diverse people and bring in that environment. And the other thing I'd point out, if we're educating the public, is I do think the students at these schools are happiest. They're not having all the acrimony. They don't feel tense. They're not nervous. I mean, I've got students in this audience that went to Yale Law School when it was like a dumpster fire, and they were scared for their safety. They weren't learning. They were terrified. And so it seems to me that those types of steps can be taken, especially at the state schools and other institutions, which aren't, you listed UVA, that actually has some very thoughtful professors that I think you and I both like, and yet they're having these courses, which surprised me, but still, nonetheless.
Down here. Go ahead.
Hey, Jimmy Percival from the Florida Attorney General's office. For those of us who, I guess, have now been conditioned to think like originalists, what's your best advice if we're in front of judges who don't think that way?
Yeah, I think that's a great question. Well, I think it's twofold, which is why I had the caveat in my speech, which was I'm not saying to leave the other arguments out. I'm just saying to include the originalist arguments. And what I found with my colleagues, and I don't know that this is true nationwide, but I think like the 11th Circuit's similar, they don't just totally disregard it. I think, back in the 70s before Scalia and Meese and Bork and all came around, I think originalist arguments were completely disregarded. They didn't even look at the text of things. And now I think everyone is conditioned. I mean, the Supreme Court said it, we all say it, we start with the text. And I know that's statutory interpretation a lot of the times, but I think originalism is similar now. And so if you include those arguments, they're not going to just completely disregard them. And at the very least, it provides you preserve the argument, so you have two opportunities. Go to the full court, meaning the full circuit court if you're in the federal system, or the Supreme Court. At least you preserve those arguments. And what I guarantee, at least once a month I have a conversation with a colleague where we say, geez, had they only made this argument? And that's what I'm saying is you have judges that are receptive. I can tell you, my circuit, almost every judge will be somewhat or very receptive to originalist arguments. So, but I think I'm not saying don't make the other arguments. I don't want you to commit malpractice the other way.
Over here, and then to Giancarlo, and then I think we'll have to stop.
Hi, Garrett Mayo, Georgetown University Law Center. At Georgetown, there's a handful of professors who are starting to advance what they call progressive originalist arguments. To what extent is it a win that progressives are using originalist language? And to what extent should originalists worry about bad actors using the ideology for purposivist end goals, such as they argue that the 13th Amendment confers a right to abortion and things like that?
Yeah, my attitude is I'm glad they're, coming in at least and acknowledging the power of originalism. And bring the horses. If your arguments carry the day, you've got the historical evidence to support it, and you can make the argument. I mean, that's the point of originalism is you got to back it up and document it. And so, if they've got it, bring it. And if they don't, at least they're acknowledging the power of originalism and where the courts are going. I think that's the one unique thing I think about the judiciary is how engaged it seems to me we are whenever presented with originalist sources. The debate isn't, we'll ignore this. The debate is what does it support? Is there enough there? And so that'd be my question is, can they bring the horses?
A nice analogy for a man from Kentucky.
Yes.
Let's have Giancarlo.
Giancarlo Canaparo, I work here. Is it enough for law schools, particularly the ones that really don't want to? Is it enough for them to teach the means and method of originalism, or should they also teach some substantive vision of the law from which the conclusion follows that originalism is worth doing?
I think that's always worth doing. I think some of the originalist scholars have made that case, and I don't think there's any harm with that. I think kind of the People's Justice, I was trying to make that case implicitly, but I definitely think there's some value to that. I think if law schools will engage with this in more than just slapdash form and actually take it on its terms, I think everyone's going to benefit, and they can do all kinds of things from that to, I guess, the originalism taught by some Georgetown scholars.
Well, Judge Thapar, really, we are so honored that you are here. I am delighted, on behalf of Heritage, to present you with our Defender of the Constitution Award.
That's I'll put it right next to my Ed Meese bobblehead.
We also have a complete set of Joseph Story's commentaries and the crib note version.
Oh, that's
here.
amazing!
You don't have to worry about putting this in your carry-on. We will gladly ship this back to
to
your chambers. But we are delighted that you are here. Thank you so much for that wonderful lecture. Please join me in thanking Thapar.